maybe 2 seconds late. Good evening, everybody. How's everybody doing? Okay, so let's see. Let's make sure that I'm live. Let's make sure that mic check. My mic is on. Looks good. If anybody noticed now, by the way, I'm going to turn that light off. Give me 1 second. I don't like that. Get that off. Get off. That's better. If anybody notices, now I can type on my computer and taking the camera, which is beautiful. Okay. What's up? First of all, Merry Christmas, everybody. I'm an idiot in that I never fully appreciated that Christmas is 10 days long. And now the song on the first day of Christmas makes all the more sense. I always, Christmas was a federal holiday. It was on the 25th. Anyhow, so Merry Christmas for everyone who's celebrating that. Happy Hanukkah, Merry Kwanzaa for everyone celebrating all the seasonal holidays. This is going to be a good stream. The amazing thing was we were in the cottage in the Eastern Townships, which in a tiny cottage, internet was terrible. And I still managed to get out 4 videos last week. I have blown through data on my phone. You can't possibly imagine. I have now, Rogers has a new plan. I've got 50 gigs a month and I'm down to 15 gigs. It's all worth it. It's all worth it. So what is on the menu for tonight? We're going to go over the Wisconsin decision that just came out because, look, I fully appreciate I'm a Canadian lawyer. I don't have any specialties in U.S. constitutional law. I just educate myself and I listen to people who I know are more informed and more educated than me on both sides. And I come to my own opinion at the end of the day because I'm not just relying on someone who says they know. I don't see how this Wisconsin decision is compatible, congruous, intellectually alignable with the SCOTUS dismissal of the Texas suit. And, I said as much in my last video when I went over it, but we're going to get into it. And I know people say, yeah, different plaintiffs, different, standing. We're going to get into it, but the parties to lawsuits are always different. It doesn't mean that reasoning in one judgment doesn't apply to another judgment just because the parties are different. The parties are always different. So that write-off doesn't necessarily sell it for me. Different plaintiff, different standing. No, different plaintiff does not mean different logic, but we'll get there. Okay, what else? Andy Dreich is in the house. I used 50 gigs when I was 15 years old. When I download one of my videos, it takes 5 gigs. It's like 10% of my monthly data in a night. Is my sound is on, right? Okay. Okay, so we're talking about Wisconsin suit. We're gonna pair it with the SCOTUS dismissal of Texas's suit. We're gonna get into. Let me just go back to my notes. It'll be easier than screwing things up. Election lawsuits, the Dominion defamation case, which is very interesting. I haven't done a breakdown video of the actual lawsuit itself yet, but I'm going to. Powell special counsel. We're going to get to Lynn removal from the Page lawsuit. And for anyone who doesn't know, L. Lynn Wood is now getting sanctioned by, or, threatened sanctioned by a judge in a different state for his professional conduct in another state. We're going to get to it. And I know Robert takes issue with Lynn Wood to some extent. I suspect, notwithstanding the issues that Barnes has with Wood as a practicing attorney, I think we might be in alignment on how we feel about this. What looks like it might be further weaponizing of the disciplinary and legal process against ideological adversaries, because I was surprised when I heard the news. Let's see what else. And then lockdown lawsuits coming out of California, the Pineapple Saloon suing Gavin Newsom and others. We're going to talk about that. And forced vaccines and face masks. Now, so here's the deal. I'm going to thank everyone in advance for the super chats, but I'm going to miss some of them, and I already can't see the one that came up early. If you're going to be miffed if I miss the super chat, don't give the super chat. I don't like feeling guilty, and I don't like feeling like people think I'm taking money without giving them due recognition. It's to show support, but I can't get to all of them, and some will fall through the cracks, but I'll bring this one up right now. Number 2, nothing in here is legal advice. Barnes is going to share his opinion. I'm going to ask my questions. Oh, we're going to talk about the pardons, the Blackwater pardons also in particular. So on the issue, what was I just talking about? Super chats. Don't get angry if we don't get them. Nothing legal advice. And What else? That's the preface for the evening. I'm going to make sure that Robert has the link to the stream, which I know he does, but just in case. Oh, rules for the chat. There are no rules for the chat. Please don't spam the chat, and no overt threats of violence. Those are the only two rules. And if you can't respect that very humble request, that's the only issue with the chat. Other than that, discuss, call names, but try not to, and have the discussion in the chats, in the comment section. Let's see. I am miffed, not about a super chat, but about the cufflinks. Little Rock. One day, I may find someone who can make cufflinks. Long live Viva, Dead North 86. Now I'm going to bring up some comments here while we're here. Viva, why don't you have a home-wired internet connection to download your videos? This is where we were. We were in a place where there was no internet connection. So, okay, let's see what we saw here. I loved your vlog that you did in the bathroom. The fact that you did it in the bathroom is so funny on so many levels, in my opinion, anyway. Yeah, it's all a question of just finding a quiet room. The sneaking away from the family is sort of a joke, because they know what I do and they know it's, beyond a hobby or a passion. It's what it is. But the only question is finding a quiet room when you are in a tiny cottage with 5 people. Finding a quiet room is not all that easy. How covert do our threats? How covert do I? Look, if I can't make it out, you know what I mean. Anybody who's doing something in the comment section that can actually, get the video in trouble or demonetized is not there to support anything that I stand for, as far as freedom of speech goes, and as far as, civil discourse goes. So, Real Bambuga, good to see you again, and thank you for the good joke as always. What do we say? I am miffed that you would think I'm miffed for missing my super chat. Brendan Saltvick. I don't know if the comment of salt in the comment section was a reference to you, but thank you. If you get in early, I get them now. And I see Robert. Robert looks like he's in a different location, but this is beautiful, people. All right. So with that said, it's going to be an amazing chat. We're going to discuss some things that might make people unhappy because it's not going to be what they want to hear, but life is not about false hope, being told what you want to hear. It's just about honest discussion and seeing things the way they are. Let's see what we got here. We're not allowed to. Okay. Okay. Thank you. Now let's do this. What is that? What is this? Okay. Viva, where's the New York Times video I super chatted you on last week? You forgot about me. I tweeted super chat local too. New York Times video. I don't know that I remember now, but email me. And at the risk of that email being already flooded, david@vivafry.com. Okay, let's do it. It is time to get started on... Okay, let's bring him in. Let's do this. Robert, how you doing?
Good.
Okay, now I know a little bit about books. That's a fake backdrop.
Yes, indeed. I'm in Tennessee. I'm in Chattanooga.
Amazing. Okay, do I dare ask why, or I don't ask why?
Holidays.
Okay, awesome. I was going to say the books look extremely old, but then the way your head meets them looks extremely green screen.
Yeah, exactly. That's what it is.
And not extremely. It looks nice. I was going to actually take a guess on the age of the books. Is it still all right to threaten verbal violence? No, Bambuga, it's not. Okay, so let's get this started, Robert. It's a big week. And let's start with the first one that's been driving me crazy. The Wisconsin lawsuit. So, Federal Court of Appeal dismissed Donald Trump. It was a personal lawsuit. This was a Donald Trump, not a Donald Trump Campaign Inc., not a third-party lawsuit. They dismissed the lawsuit. It was a unanimous 3-0 decision. They basically said, there was one part that I'm not totally clear on, but they basically said latches, as in Trump took too long to sue. Now it's going to be, you can't, what's the expression? You can't unboil the egg. They didn't use that expression, but basically they waited too long. The regulations or the procedure that Trump was objecting to, it's already been done. You could have sued for a long time ago. They said subsidiarily, even if we got into the merits, we agree with the state court's decision on the procedure having been substantially followed. And I think, that's basically it. They said dismissed. We didn't really get into any evidence. It was dismissed sort of on a procedural issue. But they said, the issue where I have is that they gave themselves standing. And as far as I'm concerned, they gave Trump standing and they gave themselves jurisdiction. And as far as I'm concerned, they gave themselves jurisdiction and Trump standing on diametrically opposed reasoning to that which the SCOTUS adopted to dismiss Texas's suit. Now, you'll tell me if I'm right and I'm wrong, and then you'll clarify one thing, because some people are saying, one was the Supreme Court, this was the federal court. So there's different courts, different parties. My understanding is that to give the federal court jurisdiction, it would be the same principle as to give the Supreme Court jurisdiction, as in depriving the state courts of jurisdiction, but maybe I'm wrong. So I guess let's get started on the beginning. I mean, it was the reasoning in there to give Trump standing and give them jurisdiction incompatible with the SCOTUS dismissing the Texas lawsuit.
Yeah. I mean, unless you're going to make a difference between a candidate and a state bringing suit. But as you went through the case, they don't draw that distinction Well, they don't draw that distinction, period, but they don't even address the Supreme Court's reference, because, again, it wasn't really a binding decision. It wasn't published. It was just put in a minute order, effectively, put on the docket. So it's not probably binding precedent of any kind. And clearly the Seventh Circuit didn't treat it as such, didn't even address the question. And then on top of that, you have the substantive analysis that they did was the same as Texas's. It was whether there was an injury, whether the injury was remedial, whether the injury was caused by the legal violation that they were referencing. So in that context, I don't see how it can make any. Your analysis is correct. The two decisions contradict each other on standing.
And some people are saying, well, Supreme Court takes precedent. So, the logical thing...
That wasn't precedent. The Supreme Court didn't make it precedent. Yes, if the Supreme Court had issued a published decision with a Supreme Court citation number, then it could be precedent, but they didn't. So that's why it's not precedent. It's like denial of an emergency injunction. Doesn't mean anything. So it doesn't even have a U.S. Supreme Court citation number. So the Supreme Court does take precedent, but their decision has no precedential value because they chose not to publish it.
That's interesting. So effectively, the Supreme Court was, when they denied Texas's lawsuit on standing, they said no cognizable injury, among other things. But they basically denied the standing in that it was a state court decision and Texas could not claim injury based on Pennsylvania state law among the defendants. But I guess if the decision in which they dismissed it was that two-liner, the precedent would not be that, but rather the historical precedent based on which SCOTUS refused to hear the case?
It has no legal precedential value at all. So it's simply that, historically it happened, but it's not a published decision. So it means nothing from a purpose in terms of a Supreme Court case of any precedential value. It isn't precedent, literally.
Okay, so now there's one thing people were saying, different parties. So this was Trump himself as an individual. Obviously, he's got injury, in fact, to have standing, whereas Texas obviously didn't have injury to claim standing. This is where I have an issue. Like, these are substantive questions. These are the issues as to whether or not they've sustained injury is not a standing issue. That's a substance issue. So people saying right off the bat, Texas had no standing, in my mind, is arguing from the conclusion that Texas didn't have standing, but Texas alleged an injury. And so in order to dismiss on the basis of no injury, you basically have to you have to just disregard what they've alleged in the absence of any ability to prove it. Whereas just take for granted Trump has injury because he was a candidate.
Correct. I mean, yeah, the only argument for a candidate having standing and a state not having standing is that the candidate's more directly tied, I presume, to the electors. But, like I said, like your analysis laid out, there's no meaningful difference between finding the president had standing or the Texas had standing on a merits basis. So and again, that's why I say standing is not a doctrine I take seriously. It's when courts want to play Pontius Pilate. And should you take it seriously as a doctrine that exists? Sure. Is it a doctrine that warrants attention? No, because it can't change your strategy, for example. I mean, because yes, if a court wants to screw you, it has 100 excuses, and like this one, I mean, it said, well, yes, standing exists, but we'll say latches because you should have sued beforehand. But like when Trump did in other states, they said he hadn't been injured yet, so he didn't have standing. So you notice they didn't even address that question in latches. They don't say if he'd sued beforehand, would we have found standing, because they know they wouldn't have. So this is why all of these doctrines are bogus. I am glad that they got to the merits. I disagree with their conclusion on the merits, And they should have spent a lot more time on it. You're talking about one of the most important, arguably the most important. That's what the founders said. The most important clause in the entire Constitution, the most debated, the Supreme Court recognized, what just in 2018 was the Electors Clause, and yet we have no meaningful resolution or no meaningful adjudication of it. And the Seventh Circuit now I'll give Seventh Circuit credit. They're the first court to recognize the concurrence that I've been talking about that the Supreme Court dodged, which is that the prior concurring decision in Bush v. Gore by Rehnquist, Thomas, and Scalia said that the Electors Clause is always a federal question and always is a question for the federal courts to resolve. They acknowledged that when recognizing that this was not only is there standing because there's an injury and the rest, but that this is a federal law question. Because people are pretending this is a state law question. No, it's not. It's a federal law question. It's interpreting the Electors Clause. Just because you're dealing with whether or not state law complies with the federal constitutional provision doesn't somehow magically convert it into a state law provision. Otherwise, every federal civil rights federal civil rights claim would be a state law claim, because they're almost always interpreting whether state law it has some component process to the issue. So I thought substantively it was a good decision on standing, the correct decision on standing, the only decision on standing, to the degree that we're going to pretend that's a serious doctrine. But the latches was nonsense. And they didn't mean, you notice they carved themselves out. They said, what they should have been honest with is, we're not going to come to the defense of Trump, but down the road, we may interpret the Electors Clause to come to the defense of someone we like, just like we did in Bush v. Gore.
And it's amazing. Now, first things first, when Robert and when I say, there was no meaningful difference in the rationale adopted in the federal court giving standing versus Supreme Court denying it, I highlighted the portion because it was the most important section of that judgment, where they said, this poses federal law questions, even though it's anchored in state law. And this was exactly the debate that I had with Nate on Eric Hundley's channel, where Nate was saying, it's obviously a state law question, separation, the state independence, sovereignty, and Supreme Court's never getting involved. And I said, yeah, I understand that it's a state law question, but it is one that has an impact on the Electors Clause, which is a constitutional question. And that was our entire debate. And that's exactly what the Court of Appeal basically said, is notwithstanding that it's a state law question, it has an impact on the Constitution, the Electors Clause. Therefore, although anchored in state law, we have jurisdiction, plaintiff has standing. How does that not apply mutatis mutandis in Texas suing, although it's a state law question in Pennsylvania, Wisconsin, Michigan, and Georgia? It has an impact on the Electors Clause, the very same Electors Clause that was alleged in Trump's lawsuit. So I just said there's no way to reconcile those two arguments. And when Nate is on Twitter saying, I got it right, the Fed court confirmed what I'm saying, I said, no, not really, because in that passage, they basically sort of confirm points that we were both saying, which is the federal court can determine jurisdiction if there's an impact on federal law or the constitutional law as created by a state law, which was the entire discussion. Where were they going with that? So, I mean, I don't know how anyone can reconcile this, but they say, okay, state law can have an impact on the Electors Clause, but we're dismissing it for the reasons we dismissed. What was I going to say now? I lost my train of thought.
Nate's wrong.
Sorry, standing. Another thing, the standing issue, where, you say standing is not a serious doctrine, and we've seen it in real time now, where standing it's a core thing. If you don't have an interest, you can't sue. But it was never intended. My argument when I present your opinion is that it was never intended to be manipulated, to be weaponized, to deny people their day in court. And we've seen it in all the lawsuits we've covered. Sue too early, no injury in fact, president campaigns in Pennsylvania. Sue too late, latches, no standing, dismissed. And so the idea of standing is now being used not to dismiss a lawsuit on the merits, but rather as a summary way of denying a day in court, which people should, I don't think is correct, but what do I know? What do they do?
No doubt that's how legal scholars that have applied it. I mean, like I said, show me any judge who's found no standing, or has found latches, or has found mootness, or has found ripeness. I'll find a case of the politics that judge likes, who magically finds standing, or no mootness, no ripeness, and finds it's ripe and no latches. So it's just not a doctrine you can take seriously, because it is a Pontius Pilate doctrine meant by judges to excuse themselves from having to make a ruling. And you can partially see why in the Seventh Circuit's decision they realize the Electors Clause, they don't know what they're doing really. They're like, man, this has hardly ever been interpreted. They should have done a lot more historical analysis. They don't, because the historical analysis would undermine their position.
And that's another amazing thing that I tried to highlight, because I'm reading it with naked eyes from a Canadian lawyer perspective, I know what I've learned over the last year or two, but they basically say this does not rise to that level of violating the Electors Clause. They said general election, they conducted a general election. Even if they broke some of the rules, they didn't break the rules to such a degree that it was no longer a general election. Therefore, they have materially or substantially complied with the Electors Clause, no violation, which necessarily admits that there could be cases where they deviate so radically, there is an Electors Clause violation, but they just say, for no better reason, this is not that case, moving on. So one thing to clarify, though, my understanding, federal courts are, what do they call them? Not a judicial construct, but rather they are a statutory construct in the United States.
Say that one more time.
That federal courts were created by statute.
Oh, yes. They're courts of limited jurisdiction.
So, okay,
with some exception. I mean, obviously, the Supreme Court's supposed to have original jurisdiction over disputes between the states. But they're otherwise courts of limited jurisdiction. What I'll give this court credit for is Trump's team did a better job highlighting the concurring decision of Bush v. Gore, and they're trying to put those two together. They're saying, okay, how was it a violation of the Electors Clause for the Florida Supreme Court to interpret election law in Florida differently than the Secretary of State, according to the Rehnquist Scalia Thomas decision or concurrence in that decision, and somehow allowing a whole bunch of people to vote who the state law did not allow to vote was not a violation of the Electors Clause. So the way they got around it is, well, they delegated it to the Secretary of State, so that means the Secretary of State can interpret the law and courts cannot, apparently. That I find that a weak interpretation. I mean, they're trying to uphold that concurrence while at the same time refusing to apply it in a manner that was far more egregious. I mean, what the dispute between the Florida Supreme Court and the Florida Secretary of State about how to do a recount was far less legally consequential than was allowing everybody to be considered indefinitely confined who decided to self-declare themselves indefinitely confined without proof when the state legislature never allowed that or authorized that.
All right, now Joshman says, please tell us how Nate is wrong. Let me bring it up. Sorry, I'm switching from the big screen to the small screen, but I think I'm just going to leave it up like this. It cuts off Robert a little bit, but it'll be better than zooming in and out.
Sure.
Robert, I mean, how is Nate wrong? I mean, Nate's not wrong. This is the issue also. Nate's not wrong in that federal court basically adopted the theory that he was promoting, which is to be expected. Everyone, Robert and myself, were saying standing was always going to be the issue. We knew how standing can be interpreted to grant, to give or deny jurisdiction. But on this particular issue, the debate that Nate and I had was that it's a state law question. Supreme Court should not get involved. In order for the federal court to get involved, it's the exact same principle as the Supreme Court getting involved in a state law decision. And so the federal court here giving themselves jurisdiction is, I guess, effectively the evidence that Nate is wrong on a certain issue and that the federal court was interpreting state law, if only to agree with the original interpretation.
Yeah, well, there was a much more powerful argument for standing for the Texas than there was for the president, because there was an original jurisdiction case of a dispute between the states. So it was always a red herring to say, oh, you can't get involved in state elections. That's just not true. I mean, so what would he call the Voting Rights Act? I mean, some of these arguments I'm hearing are they're lame arguments. It was always the case that if a court doesn't want to hear a case, particularly in the election context, it's got 100 excuses to not hear it. That have most of which have been developed over the last 100 years or so for getting rid of political cases they don't like. That's all that is. I mean, I can't take it seriously as a legal doctrine because it's not. I mean, the analysis is there a case or controversy between the parties? I mean, that's the constitutional standard. So the standing is a ridiculous application of it, because when you ask it just like that, is there a case or not? Is there a controversy or not? Everybody's like, well, of course there is. So then so what exactly is standing? It's an addition to the Constitution. It's an amendment of the Constitution that is courts, and this is how it's been interpreted by leading legal scholars. I mean, so it's not like it's a shocking development. So people celebrating themselves for the courts finding Pontius Pilate pretext to kick cases. Congratulations on the courts being cowards. But I don't think that's it's not an argument. Like, even when I believe a case will get dismissed for standing grounds, it's because I think the courts are politically want to stay out of the case. It's not because I take standing as a serious legal doctrine seriously, because courts don't. If courts did, it should be applied with consistency. It's not. It's applied in a disparate and discriminatory manner by the same courts, not just courts over time. You'll find the same judge will make contradictory rulings on doctrines of standing, on doctrines of ripeness, mootness, and laches. Here, I think, I'll give the Seventh Circuit credit for at least trying to get into the merits, but I think they got the merits wrong, and I don't think they did the merits good service. In other words, if they were going to be serious about doing merit in the merits, they needed to dig into the history and do a 30, 40-page ruling on the Electors Clause, every interpretation of it, historical application of it, understanding of it, really dig in more to what Bush v. Gore was saying in that concurrent decision. And they skipped it because they want to skip it because they don't want to help Trump. I mean, that's the reality. The courts will not come to the defense of Trump. And it doesn't matter what party the judge is from. It's interesting to me these cases keep magically getting assigned to Republican panelists. How do you get 3 Seventh Circuit judges all appointed by Republicans to screw Trump? It's all random assignment, folks. Don't worry.
Well,
it's just interesting to me.
And I tell people, I know when Robert goes from interpreting the law to his personal opinions. And I know people look at these things and you make connections. Now, in fairness, Robert, if it goes to 3 Democrat judges, one would say, oh, they're giving it to the Dems to throw. If it goes to 3 Republican judges who throw it, you're going to say, oh, that's evidence that the system is against them. These are theories and interpretations, but not the meaningful sort of facts in law, which are.
Oh, sure. No, it's definitely speculative interpretation. It's but I mean, it's what I've been saying from the get-go. It was clear very early on when Trump judges were denying Trump. And once the Supreme Court denied him, that was a message. I mean, and this isn't just my interpretation. Dershowitz had the same interpretation. He said the Supreme Court was sending a message to everybody, stay out. And all the courts have taken it. But put it this way, if you wanted to make your case, if you're the court, and you think, we'll have credibility if a bunch of Republican judges do this, I just find it's do you know how hard it is to get 3 Republican appointees out of the Seventh Circuit? The odds of that are like, I've had a bunch of cases in front of them, and I've never got that panel. I've never got that lucky with my life on a case where I would say like 3 Republican judges, which aren't not that's not always the case. Sometimes I want 3 Democrats.
But Robert, now, I mean, I know you look at it and you're going to see things, they see that it's sort of, I know you think the establishment, people think it's political bias, and it's, the argument is that it's just institutional bias.
Yeah, it could be both. Yeah. I think the professional class as a whole hates Trump. I mean, it's just, and there you can look at polling data, you can look at voting data, you can look at the judiciary as a whole has not come to Trump's defense. It's come to the end, and this is the problem of putting Federalist Society people on the bench. They're people who are corporatists and institutionalists. They're not people who are Trumpists at all. And from a general historical populist perspective, the courts have been the historical adversary of populist causes, whether it's from the left or the right. It's been the rare exception, the Second Amendment case here or there, church case here or there, but the church has a lot of institutional support. So that isn't always populists may align with it, but it's not always necessarily a populist cause intrinsically. So where you have just populist causes, courts have usually been the adversary historically. And that's because the professional class as a class has historically been the main group of people that oppose populism in all of its forms over the last 150 years.
Well, no, and here's the problem is, I know that that's your view because we've discussed it before. Other people are going to look at this and say, look, the lawsuits are so frivolous, even Republican judges, even Trump appointees are throwing them out. And so it might just be, it's either confirmation bias where it can never be disproven. And the more that happens to dismiss them is, on the one hand, going to confirm for some how frivolous they were, and is only going to confirm for others how corrupt the system is. At the end of the day,
that's deference to power. So by that standard, every civil rights case brought from 1885 to 1949 was frivolous because it was routinely and regularly thrown out of courts. So I don't take arguments from power seriously, other than, you have to deal with that's how power operates and strategically adjust accordingly. But just because someone has power and is able to wield it in a particular manner doesn't tell me whether the principle is right or wrong. And the fact that they have gone to great lengths, for the most part, to avoid discovery, avoid trials, avoid substantive rulings on the merits, even in many of these cases, not Wisconsin, but in many of these cases, tells me they're not, that the merits are not so strong on their side. If the merits are strong on your side, you go right to those. You don't rely on procedural gamesmanship. You go right to the merits right away, and you say, here's why the merits don't work. Here's why the Electors Clause. But they know that. I mean, the other giveaway is here you have the Seventh Circuit recognizing up front the Electors Clause is an issue that really needs adjudication and doesn't have a lot, but we're not going to do a lot either. So I mean, if they were serious with it, you'd see a long, detailed ruling that when you read the content of the argument would be persuasive, not, hey, I have power and I can screw you. I never find that latter to be persuasive, not as a matter of principle.
And now, actually, the groundhog brought up the question, what does this mean for the indefinitely confined ballots in Wisconsin? Now, first things first, in that decision, and this was a factually surprising thing to me because I didn't understand it to be the case, Federal Court of Appeals said that the state court judge blessed or sanctioned, in the positive sense, the indefinitely confined instructions, which as in he authorized them. The lower court judge.
They said the Wisconsin State Supreme Court did. That was their interpretation of it. My recollection of Wisconsin is the Supreme Court decision was they didn't rule in favor of Trump, and I thought it was 4-3 split actually with the same judge that screwed over. By the way, is it a coincidence that the same Republican judge who screwed over Trump is the one who made sure the Green Party couldn't get on the Wisconsin ballot? I'm supposed to buy that that's some sort of logical consistency compelled those conclusions. One time we have to strictly follow certain election laws, and the next time we don't. And the only consistency is helping Joe Biden, hurting Trump. We'll see. But they sort of skipped over the fact that 3 judges dissented. I get 7 judges, but and that's what I mean by if they're right on principle, then you'll address that. And you'll say, here's why even the dissenting judges were wrong, and they don't. They skip over it entirely and don't address. And that's where I'm saying that if their arguments were powerful on principle, they wouldn't be relying on procedural tricks and short shrifting substantive arguments in the way they routinely and repeatedly are.
And that's the thing that drives me nuts is because I've been following it, but I didn't follow every court case. But my recollection, my understanding was not that the courts gave it their blessing. I thought there was a substantial debate on the legitimacy of the practice that had not been.
It was clearly the legislature didn't authorize it. There's no dispute about that. And so the only question becomes, how much discretion does the executive have to interpret statutory provisions? And indefinitely confined clearly was not intended to mean COVID, if it was. But this goes to all of the issues. What happened was Democrats who wanted to help Biden supporters did not have the support of the legislatures in all these key swing states. So they went around them. And the question is, does the Electors Clause allow them to go around them? And if they were honest, that's how the courts would address the question, because they know that's the politics that's playing in the background. None of them will even admit that. Their arguments are so persuasive they have to hide from the core facts. And that's where it makes me think they're not persuasive. So, but yeah, and in fact, clearly they didn't fit the definition of indefinitely defined. I mean, like they should have explained what would be example. The fact they left it open just shows how political the decision is and how they want to leave it political for themselves, because they should have said, okay, what would be a violation of the Electors Clause? Could Wisconsin say, we're going to allow Canadians to vote in our election? Would that be okay? Would that just be part of administration? That might be an error that doesn't impact the Electors Clause. I mean, you noted there were good arguments made in the brief that they skip, and I always recommend this to people: never take a court's rendition of the arguments as the actual arguments made. And read the briefs and see what the arguments actually were, and notice which ones they skip over.
And this was not an exercise I was able to get into for this, but I did it in Flynn, and we read Sidney Powell's briefs. You saw the arguments made in the briefs, and then when you compare them to the judgments, when it happened, it's eye-opening. Now, I didn't read the briefs in this. All that I know is that you could tell where there was glossing over, oversimplification, or outright confusing stuff, like with respect to the sanctioning of the indefinitely confined criteria. But
for instance, errors. There might have been errors made. Well, that's a famous Nixon statement, right? To deny responsibility. Oh, mistakes were made. Who authored those mistakes? What were those? No authorship, but errors might have been made.
And errors might have been, but at the end of the day, it was still done by general election. So therefore, they substantially complied with the Electors Clause.
Let the Canadians vote. Why not? Would that just be an error made? Still would be a general election, right? They are complete. The whole point of the Electors Clause is to give the legislature exclusive discretion and control over how the election is conducted, and pretending that they can rewrite the rules in the name of interpretive power is a problem of the administrative state in general, but it's just not consistent with what Wisconsin law provided for. And they're basically saying, hey, look, we got away with it. We don't like Trump. We're not going to give remedy. End of story. And I get it. That's where the courts are going. Now that gives Trump legal ammunition before Congress on January 6th. But it's clear I have no respect for any of these decisions that have been made. I just don't. I see them as politically motivated, and they are not persuasive. I don't think any one of these people could, go to the Yale Political Union or Oxford Union and debate me for an hour and have their argument hold up as persuasive to someone who didn't have an opinion on the subject walking in.
And the thing is, as a lawyer, you can, as a reasonably analytic person, anybody can see this. The next time they'll say, if they want to side with the campaign, the petitioner, the plaintiff, the candidate, they'll say, oh yeah, that case, it was not a material violation of the general election. In this case, it is, therefore. And you can just see it's that easy to do in law, and it really irks people. And I read the comments. There's a reason why people hate lawyers. They don't like judges.
That's the thing I think a lot of my legal colleagues are underestimating. I understand these have been Pontius Pilate pretexts that you've been able to get over on people in the past, but most people were unaware of them. Most people had never heard of standing. And for the ordinary person, these are unpersuasive. And what it really is, it looks like Pontius Pilate. And the only people that are convincing themselves that this is a legitimate excuse are the Pontius Pilate fan club. And they don't understand that the courts look horrible in this whole thing. They have lost probably 10, 20% of the American population that will never look at the Supreme Court or our federal courts the same again. And why? Just because you hate Donald Trump? I mean, it's pitiful, frankly.
That's amazing. And we got our first chat from Cleopatra. Cleopatra, welcome to the chat. Merry Christmas, David and Robert. So this is it. Again, time for me to flee for a while. Robert, our restaurants open in Las Vegas.
Some are. I mean, I'm in Tennessee now, so we got mandatory masks everywhere, which is driving me nuts. But in Chattanooga, Hamilton County, our mayor got to make sure he loses next time. But yeah, I'm not sure whether Vegas's restaurants are open or not. But I think, the January 6th is going to be the determination day, and we can get into what the probabilities of that are. But that it's clear the courts are not going to come to remedy. There's a bunch of cases. That Seventh Circuit case will now be up before the U.S. Supreme Court.
Oh,
but
I was going to ask.
Is scheduling things to be past the inauguration day. So,
I'd love to see how is the seventh. Sorry, how would the SCOTUS now say we're not hearing the appeal on standing? They'll say, Trump has standing because he was the candidate, whereas Texas didn't have standing because they were a state suing another state. So they'll be able to, I say, weasel out of it, for lack of a better word. They'll be able to distinguish it in law in a manner that will be, like you say, unconvincing for anyone who's paying attention, and convincing for those who want to believe, who like being told everything is working the way it should.
My hope is that there's enough public outcry and public criticism that they take up, even though they're not going to issue remedy for Trump, that they do take up one of these cases and stop this from happening again down the road, and say the Electors Clause means the laws have to be strictly enforced, and if the laws are materially unenforced in a way that changes potentially the outcome of an election, then that's an Electors Clause violation. I think a lot of the remedies here are going to have to be legislative in nature. The legislature reasserting their authority. They should take over election contests for presidential elections. They should be the ones to certify, not have governors or secretaries of state certify. Precondition the governor's certification on their certification. A lot of other things that are probably is going to have to happen. But I hope the Supreme Court takes up a case and stops this from happening in the future, knowing they don't want to help Trump, but at least don't abandon their duties and tasks altogether.
All right, good segue actually to what happens next. So, Federal Court of Appeal, the Wisconsin decision is going to go to SCOTUS. Nobody's holding their breath. Don't hold your breath. There's not enough time. I would imagine. Even still, they'll find a way to hear the case, give standing, and affirm the lower court decision. What happens January 6th now?
So January 6th is going to be when the Congress decides whether to certify. And so there's a bunch of House members who are clearly going to object. So there's going to be plenty of objections from the House to a bunch of different states' electors. The question is whether a senator joins them. And Mitch McConnell has been lobbying. Reason why I've been lecturing people about Mitch McConnell being a problem is now made more evident. McConnell is doing everything he can to cost the Republicans the Senate because of his incompetence. That's not deliberate. What is deliberate is his attempts to sabotage Trump, and he wants Trump out of the party. And so he's been working the senators to have no senator object. That would be a monumental mistake of the Republicans. The reality is Trump it has a very uphill battle getting enough votes under the Electoral Count Act of 1887. So the two potential remedies is one, and so people were calling it the Pence card. Now there were some memos leaked that were not necessarily actual memos, but they do outline the legal idea that we've been talking about here, which is that under the 12th Amendment in the Constitution, there's an interpretation of the law that the vice president has a non-reviewable discretion to count electors. What's clear is that it gives the vice president the choice to count electors. So the question is, some people say that's a ministerial obligation. He has to read whatever the governor certified. Others say, no, he has the power to determine whether or not that's the actual correct electors. And so he could get up and say, count Trump electors or not count any electors from the contested states. In that context, then Democrats would object, but then the burden would be on Democrats to get a majority from the House and the Senate to override the objection. Or to sustain the objection and put in the original governor certified electors. Assuming I don't believe Pence will do that. So there's a lot of stories about Pence, the noble guy. Even when he was at CPAC, his idea of being noble is to say we'll count every vote and we'll fight to make sure no illegal votes are counted. We'll see. He said very little otherwise. People have asked me why I'm skeptical of Pence. When Trump was going through the Access Hollywood stuff, Pence was angling to replace him at the top of the ticket. So the loyalty is not his number one virtue. And second, he was the guy who principally drove Flynn out. And third, his staff has been a constant source of he keeps hiring never Trumpers. Ask yourself whether that's really an accident or not, who sabotaged and leaked throughout Trump's presidency. And then he, of course, was the one who coordinated to force Ecuador to give up Julian Assange for the purposes of his arrest. So Pence is an establishment guy at heart. Trump picked him because he appealed to the evangelical base that Trump had some potential weakness with. The church-going suburban evangelical vote didn't translate a whole lot, but that's another story. Ann Coulter and others were critics of Pence from the time he was chosen because he was an unreliable ally. I think, in truth, if Trump had picked someone like a Matt Gaetz or someone like that, he probably would have faced less trouble. Pence was seen as manageable. So I don't think Pence will do anything. Pence clearly could act. Now, the way I tell it to people are like, well, what vice president would ever do this? Does anyone doubt if this was Kamala Harris or Joe Biden in 2012, they would absolutely be exercising their discretion? Lawrence Tribe would be doing long Twitter threads about how this was clearly the constitutional interpretation all along. But I just don't think Pence will exercise his potential authority. And I do emphasize it is potential. I mean, there's no vice president has ever exercised this authority before, and it is still a legal argument as to whether he has it in the first place. But there are liberal legal scholars who have concluded that he does. So it's just a difference of opinion on that. But I don't anticipate Pence will. Then the big question is, will senators object? I think they should. One, it's politically savvy to object. In fact, it might be political suicide not to object. But Trump still has an uphill battle because under the Electoral Count Act, if that's constitutional, which is a second separate question, because there's a good argument that how can you bind a future Congress when this is a constitutional mandate and the first inception? So there's an argument that the Electoral Count Act can't be binding on subsequent Congresses. So what it's safe to presume, given Mitch McConnell and Pelosi are in likely control, or if Schumer's in control, Schumer, there likely won't be a decided election on that side of the aisle yet. So Mitch McConnell will be in control, but he's not going to help Trump at all. He's made that very clear. He's begging people not to even object from the Senate. Is that he will enforce the Electoral Count Act. Now the question is, what does Pence do? Because Pence is the president of the proceedings for these purposes. So will he adjudicate it differently and say the Electoral Count Act is enforceable, or if either house sustains an objection, the objection to the elector is sustained? That's still, it's going to be, it'll be a fun show to watch, because I think some senators, I don't believe all of the Republican senators have a political IQ under 50. There's a good argument that almost all of them do, but I can't believe that Paul or Cruz or Hawley or Tuberville or all the rest are that suicidal that they are, I get like Toomey, apparently he's not even going to run for re-election in 2022, so he'll take his pot shots on the way out. I get Cornyn, anybody who just got elected feels very confident. But anybody facing any kind in 2022, for sure, you better get on the Trump bandwagon now and object. A senator will have to object, and then they'll all be forced to go on the record and vote, and at least have 2-hour hearings and allow some evidence to be presented. If they did this,
actually,
right.
Two questions. The procedure for objecting, what does that look like? And what does that entail? And what is the Electoral Count Act that you're talking about? What's the overarching principle of that act?
So after 1876, they did two things. One, they actually put into law that the military could never be involved in an election again, made it a federal crime to do so. And that has a bad history because the history of that was allowing the Klan to seize power in the South. That's why they did it. People praising that statute tended not to make reference to that, but military can't get involved. That was one part of their resolution of the 1876 controversy. The second was, well, let's have some means of deciding this in the future. So we're going to decide future electoral count acts that, one, the electors will only count the electors that are certified by the governor of the state, because that was a dispute in 1876. You had competing electors sent in from different bodies. The official canvassing boards all said one person. State legislatures, or in some cases just the electors meeting, sent their own. So to avoid that controversy, they said, we'll accept the governor's certification in the future. Secondly, the way we will object is that a House member and senator have to join in the objection, and then each chamber will convene for 2 hours, come back and vote on the objection. There's competing interpretations. I mean, like I said, the Electoral Count Act has been described as a disaster of a statute because it's one of the most poorly written statutes ever in our history. And because there's some interpretations that both chambers have to vote the same way. There's some that say only one has to vote a certain way. It's honestly unresolved, and that's where the role of Pence could become critical, because he could interpret it as president of the proceedings. But on paper, it's currently interpreted that both the House and the Senate have to sustain the objection, otherwise the electors count. There's a presumption of validity if the governor has certified the electors prior to the date that they did, which was the December 14th meeting of the electors 6 days before. So, and if the House and the Senate sustain an objection, then those electors are thrown out. And sometimes you could have choices of electors. Sometimes it's just electors don't count from that state. There's a controversy about how that impacts things. Theoretically, what could happen is if Biden does not have 270 electors because enough electors have objections sustained to them, then the 12th Amendment says you have to then go to the House to vote by state delegation. My argument has always been that if you can the power of the 12th Amendment is the power to determine whether an election is contested, as well as what to happen when it is. It makes no sense to me to allow Congress to circumvent the 12th Amendment by saying, no, we're going to take away the 12th Amendment's power because we're going to decide whether or not there's a contest in the first place. And that will in turn deprive the 12th Amendment of any power. You could always do that. So that's why I think now the question is, who could sue? Could a congressman sue the Congress on grounds that they violated the 12th Amendment, and how they're going to handle this, and who would adjudicate it? I'm sure the Supreme Court will find some excuse to dodge and hide and run as usual, but at least in theory, they should hear such a case, because it's an unresolved question. In other words, how do you enforce that 12th Amendment provision when the Congress has no incentive to have the 12th Amendment enforced anymore? That they don't want to sacrifice their power to state delegations. They want their majority power to matter. The Senate doesn't want the House to get to pick by state delegation. That makes them irrelevant. That's why they're dodging it and evading it. But theoretically, that's what could happen. Trump's objective would be to have the House and the Senate sustain objections to enough electors that it goes to vote to the House to vote by state delegation, where he is favored. The alternative is at least he gets everybody on. He gets an opportunity for Congress to hear the complaint. We set up a good precedent that Congress is supposed to resolve this. The other potential component of that is that the president at least documents and details who's on his side and who is not. And I think that's the other part of that's of use. So I think that it's useful for the country to see, and for Trump supporters to see who's really been Barzini all along, to quote the Godfather.
Okay, that's actually was my next question. Sorry, I had to refresh the chat, so I had to. Now I can see people chatting. Is it televised on January 6th? Is it going to be like congressional hearings, or is this going to, be slipped under?
It should all be on C-SPAN. So that's why it could be fun, entertaining, and that's why Trump is organizing. He wants as many people there as possible, because he wants them to remember. It's extraordinary. The Republican establishment really is running from Trump as much as they possibly can. And they thought that the fact they had all of their own allies in key executive positions in these key states and key courts that were loyal to them rather than to Trump, or even in my view, to core constitutional commitment, they thought would be enough, and they're wrong, and they're still clueless. They're completely clueless. So they're politically out of touch. It would be political suicide for the Republican Party to not object to these electors. It just would.
Well, I mean, but I guess some people are going to say, "What are you going to do in a two-party system?" So it's suicide for now.
Yeah.
Collective memory is short, and what are they going to do? Vote Democrats or start a new party? Which is what
I'd say the two things. I mean, I think Trump will likely still stay within the party, but the probability of everybody will start getting primaried. But if they want to create a third party, this is the way to do it. I mean, the third party split over major issues. If every Republican in the Senate wants to remind the Trump base that they wasted their time voting for them because they won't even vote to object to allow a hearing, tells you something that is deeply, deeply wrong with the institutional Republican Party, which they should have recognized. That's why Trump got elected, but they see it as an anomaly, that they can just go back to business as usual. I mean, that's why they're passing crazy laws that are padded with dumb things, and not giving, and then blaming Trump for the tiny little bits of crumbs they sent them, the American public. So they're just politically, they just don't realize the scope and scale to which they are. But I think a senator will object, and we'll have multiple hearings. And now people have talked about, theoretically you could object to every single state, and you have 2 hours that could go on all the way up until Inauguration Day. The last time we had a meaningful contested election was just 4 states. And this gives you an idea. This is what Democrats would do. What they did back then, they used every procedural tool they had, even though they knew that the state canvassing boards had certified the Republican winner. They were going to contest because their state legislatures in those states, or their electors in those states, had said they won. Won by the margin of fraud, is what the canvasser said, because they threw out a bunch of ballots as coerced or illegal. And they played every game. They delayed it for 2 months, because back then inauguration was in March, and they dragged it out every day. They filibustered like mad. They did every possible procedural shenanigan they could find, and they leveraged a lot of benefit out of that. They got control of the South again because of it. They eliminated the Republican Party in the South for the next almost 100 years. So that's how Democrats fight. Republicans are tactically foolish and ideologically out of touch with their own party.
So Scott Ewing says here, is it true that every Republican president-elect since 1988 has been objected to by a Democrat in the House?
Yes, that's correct. So they objected in 2000, of course, but no senator joined. In 2004, Barbara Boxer did join to Ohio about voting machines, no less. That back then, Diebold, the voting machine maker, was a Republican and had said a bunch of pro-Republican things. And so the argument was that the Ohio was stolen by machines. They had data analysis to support that too. Now, if you looked into it, the data analysis wasn't so strong, but on paper it looked good. It was only if you didn't know the political context that you understood its vulnerabilities. But yeah, so in 2004, and so to both W elections they objected, but nobody objected. I don't think any Democrat has been objected to since 1876, when the Republican was ultimately put in. It's just the nature of who wields power for whom. Mitch McConnell wields his power. He just wields it for establishment types. And even though Trump gave his wife a nice gig as the Secretary of Transportation, who refused to enforce the anti-disability rules involving masks for autistic kids and other people while she was there, I'm sure she's going to cash in as soon as she leaves. Trump is just making that harder for everybody to get rich quick. That the institutional Republican Party has been corrupt for a long time. Both parties have been. It's just, I think this is beneficial for the country to witness, because let's see what happens. We have a constitutional process. Our courts are scared to get into it. Our executive branch people are scared to get into it. Let's see if Congress can at least step up and do at least a little part of it.
All right, and I'm going to bring up 2 chats because I think this one deserves to be read specifically. RB, I think you misinterpreted the meaning of the restriction of the military in elections. The South really objected to the U.S. Army's occupation of their states during Reconstruction. 1876 saw that ending as part of the deal.
That was part of the deal, but then they later passed laws, 2 statutes, which made it a federal felony for any military officer to get involved in an election, period. So research those laws, research the history of them. They codified it. Yes, the agreement was that they would physically withdraw the troops, but Democrats didn't trust that. They said, no, the law's got to be passed that locks this in, and it did. So that's why that happened.
All right. And now Pink Sniper 28 says, say I wanted to run against my senator in 2022. Where do I even start? I'm an engineer, not political Jim.
Well, these days, what Bernie Sanders helped revolutionize on the, he coming from the populist left side of the perspective, is that anybody can run these days. If you build a good social media network and you build a fun, a grassroots donation base, anybody can run for anything. That doesn't make it easy. There's still a lot of hurdles, but the ability of grassroots donations means the donor class no longer controls who can access elections.
No, the donor class doesn't, but the tech class does if they decide to shut down your support channels, I guess.
That's where, I think in the future, candidates can form locals boards, and locals boards could be part of a way to support them, to stay connected, to stay involved, to be outside of the Facebook, Twitter monopoly. They can put up podcasts and videos there as ways of distributing their message. So I think there's new technologies emerging that can help popularize. I mean, one of the reasons why we created the locals board is to use as an example that others can follow in as a method of organization.
And if anyone doesn't know, we're on Locals, vivabarneslaw.locals.com, and it's Robert is extremely active there and actually answers, I think, pretty much every question without guarantees, but from supporters.
I read all of the comments from all subscribers, and what questions I can answer, I do. Some I don't often have an answer to at the time. So, but I'll usually will try to get to it if I can.
Would Viva and Barnes do a live cast for the counting of the electoral votes? I have been have been burnt by YouTube attempting live streams where you react or broadcast something else, because rebroadcasting can be problematic. So
I'll be in DC. I'll be there.
Okay, awesome. Do we go into so for the election stuff? I mean, I think that pretty much covers it where we're at now. Any big lawsuits coming up?
They filed suit in DC to try to require Vice President Pence to exercise some duties in reviewing of the electors. I don't anticipate the suit getting anywhere, but I'm glad they're pursuing every legal remedy, exhaust it, prove whether the courts are open or closed, establishes the basis to deal with Congress. It also establishes the future basis for legislative reform.
All right. And I'm bringing this one up because we answered this question earlier in another stream, and I think I know the answer. How do you see the Georgia runoff election going? Also, is it true due to Georgia law you cannot vote in the runoff if you didn't vote in the primary? Robert, am I wrong?
To be registered.
If you were eligible.
Yeah. You're right. You can actually register afterwards. You just have to have been eligible to vote for the general election in order to, not by the primary, but by the general, in order to participate in the runoff. They're in trouble, but Trump's going to try to salvage them. So he's going down there I think the day before election day for the runoff, January 4th, and he's going to hold a big rally. They're in big trouble. The key problem is not your registered Republican. The key problem is working class Trump supporters that are independents tended to own. There's a whole bunch of them that only tended to vote when Trump was on the ticket. So they have no reason to get out now, and McConnell's making it easier and easier for them not to vote because the guy's a moron. He's politically incompetent. What he's good at is backstabbing people. He's very skilled at that. That's the only thing Mitch the turtle is good at. He's doing everything possible to ruin it for them. Right now, if the election were held today, Democrats would win both seats. But there's a chance that it puts away. If Republicans win, it will solely be because Trump went down there and personally dragged them across the finish line.
Okay, excellent. And this is a good segue to break into the next subject, which, speaking of defamation lawsuits, so Coomer suing everybody. Coomer is he was the director of strategy and security at Dominion. He is suing. He filed suit, defamation, and among other other type claim against OANN, Newsmax, Giuliani. Who else? Rion Chanel. I forget her. I think that's her name. Rion Chanel.
Yep. The Gateway Pundit.
Gateway Pundit.
And obviously, Sidney Powell. And I think, did they also name Lynn Wood or not?
Yep. I'm 99% certain they named Lynn Wood. So going after everybody for defamation. If you read the lawsuit, I think a lot of people are going to be too emotionally invested to pull back a little bit and see what happened. Whether or not you think, whatever you think of Dominion, you pull back and you look at this individual who's just, a principal of a company who, if the allegations are true, suffered quite a bit. Whether or not you think he deserved it, he suffered quite a bit. And at Ottman is the other guy, the podcaster who started the snowball rolling.
And Michelle Malkin and
Yeah. So the allegation of the lawsuit basically is that, there was an unsubstantiated, unverified allegation made on a number of podcasts by an individual named Ottman. I don't know who he is, and I didn't look further into it, but I know he has a podcast and there's a report. He has another channel that he talks on, who basically said, I infiltrated a conversation held by individuals and heard someone by the name of Eric say something, never Trump. We're going to make sure Biden wins. I'm cutting out names and cutting out words to keep it clean. The guy says, I don't know who this Eric was, but I think it's this individual, Eric Coomer. Yeah, Coomer. And that's how the ball gets rolling. OANN reports on it. Newsmax reports on it. The individual Coomer starts, getting doxxed, threatened. The worst thing you can imagine if what he says is true, and no reason really to doubt it. It's the world. Internet is what it is. He's suing for defamation now. And this is part of the strategy of Dominion saying they're going after people, Smartmatic saying they're going after people, issuing letters for retraction. So that's the nature of the lawsuit. It reads relatively. I mean, it reads well. I had some issues with the drafting, but we'll get to that in a later vlog. Two things people are saying: why is Dominion not suing, and why is the principal Coomer, or not a principal? I don't know if he's a principal, but why is the individual employee Coomer suing?
So, I mean, I think he's just starting out of the gate. I'm sure Dominion is going to be suing. I'm sure Smartmatic is going to be suing. So they are escalating they're sending litigation hold letters out and all of that. And they're getting some retractions. Every Fox connected network issued retractions all over the place. And then Newsmax did the same. They did it all over the place. I don't think One America News Network has, and I don't think Gateway Pundit has. And obviously Powell and Wood are not. So from those who are on the Powell Wood perspective, they think it's great because all kinds of discovery will be found. Wood is out tweeting this today, I believe. And so that's their perspective, is that they'll have an opportunity to prove their case because truth is a defense in a libel case. And now they'll get access to a lot of information and whatnot. And we'll see. My own view is that I suspect that a lot of their theories and a lot of their allegations are not true. And so as to Coomer, they clearly didn't. One, he may have a pure negligence standard because he's probably a private figure. And so him individual. So I think the reason why I think they set this up to be lawfare is what I think, because here's what I find peculiar. You're in Dominion's position and in Coomer's position, and you're almost silent for a month, effectively. In other words, you put out statements on your own web pages, but you don't threaten litigation right away. You don't make a big stink out of things. You dodge one hearing at a state legislature. So you even act suspiciously to some people who are looking at things. And what you do is put it this way, here's what it allows to have happen. It allows what I believe to be a disinformation campaign, a distraction campaign, a self-discrediting campaign to really fully develop and full flourish, and allow a lot of the cases and arguments to get derailed in the court of public opinion, allows people to make statements that become incriminatory from a defamation claim perspective by waiting in the way they did. So if I was right that it was a disinformation campaign and that Dominion at some level was a willing participant to allow that disinformation to develop, they behaved like someone who would in the sense of the timing of their objections. But however that may be, the reality is that, how are they going to prove, how are Powell and Wood and the other defendants going to prove that statement they attributed to him is true? In other words, it had all the hallmarks of being false. I never repeated it. I start off with a simple thing. Look at Dominion and look at whether the evidence shows that Dominion machines influenced the election. So you compare the counties in a bunch of states. Dominion is only in some states, not all of them. So, and then they're in only some states, not all states. So compare them all and see if you see a disparate voting pattern show up. In Dominion counties, Trump improved by about 20%. In non-Dominion counties within the same state, he improved by about 20%. Biden improved by about 25% in Dominion counties in terms of vote totals. And in non-Dominion counties, there was practically no difference wherever Dominion was present. So it was clear as like, I can't show a material voting impact by Dominion. So it's a waste of time to pursue it because that clearly isn't where things went AWOL in this election. The second way I knew is as soon as I was down in Georgia, they were eager to do a hand recount. They wanted the blame to go to the machines because they were ready to prove they had nothing to do with it. And people forget the hand recount that was done. If there was any algorithmic manipulation or fractional or any of that, it would have shown up. In Republican counties where Republican observers did get to watch the voting process, there was no evidence of any machine manipulation, period. So once those two things had happened, it was a waste of time to continue to focus on Dominion, and yet they continued to. And to me, that was a sign of a disinformation campaign that whether they were willing participants or just total suckers, they clearly had been taken in by. And then the worst thing is, I always tell everybody, my media clients and other people, be very careful about making specific factual statements about specifically identified people or businesses, unless you're absolutely, you really feel well grounded in the accusation. Now, if you're accusing like Bill Gates, okay, he's not going to run around suing people, but private people, smaller, business enterprises that aren't necessarily really big, they will. And people should have been paying attention to what happened to Alex Jones in the Sandy Hook cases. My view is that was lawfare that was being promoted by the press, hoping people would repeat it in the future. So if you're in the alternative independent media space, particularly be very careful before you're making specific allegations about specific people or businesses that have, and here's the big difference. People are asking me, well, why do you think there could be big damages? Because these are companies that can prove 100 million plus in damages if they don't get certain contracts. That's why one contract in one state gives Dominion 106 million just in Georgia. If they lose that contract, boom, and they can blame this, all of a sudden you have real damages, not just emotional distress.
And incidentally, I'm bringing up this comment because when you say about making specific factual or unfactual allegations about specific individuals, this was specifically one of them that was repeated over and over again in the lawsuit. The guy said, there's a recording. Sidney Powell said, I have a recording. Other people said there's a recording. OANN or Newsmax, one of them reported there's a recording. The plaintiff denies there's a recording, and thus far, nobody's provided a recording. So
there is no recording. I mean, I started looking into this. It turns out almost all these sources are Q-sourced in one way, shape, or form. Almost all this stuff is coming. First of all, think about it for a second. Do you think this really super sophisticated foreign spy company operating on with the CIA and China and Venezuela and the ghost of Hugo Chavez and everything else, do you think that their head of security has a Zoom call? First of all, Zoom call conference with Antifa? That isn't how Antifa organizes, folks, on Zoom calls. So, I mean, right away, I was like, what? And then he's going to admit on this Zoom call that could be recorded by people he doesn't know that he personally has made sure Trump can't win? This was incredulous on its face. I mean, people should have recognized there's almost no chance that story's true. So they bought a story that was obvious nonsense, and I think they believe that someone had the proof. Because like the way the whole German server nonsense started, it was a Q source in Germany. I started tracking and tracing these down. This guy that was the colonel that Rudy, for whatever reason, put on panels. That it turns out he was a forklift operator apparently at a brewery in Dallas, and he has never been put up as a cybersecurity expert that I can find until now. And suddenly he's a cybersecurity expert. And he's appearing and testifying before these state legislatures, and he had all the white hats had hacked the black hats, and they could prove all the information traveled to foreign servers. It turns out that apparently his source was another QAnon source. So they're getting all these Q sources that say we have the evidence, and they believed it, which goes to further evidence that I think Q is a deliberate psyop increasingly, but because of its sophistication. But the information they should have known. I mean, just apply your trial lawyer skills to what evidence is likely to be true and provable, and what evidence is what somebody wants to hear. I mean, how many times have we had a client that tells us this evidence exists, or that person will say this, and we listen to it and we're like, probably not. They applied no discipline in their analysis here, and Sidney Powell got taken for a ride, and Lynn, I think, like I said, I think Lynn's been crazy now for at least a year. Now he thinks that car accidents are part of a conspiracy, that the Nashville RV is part of a conspiracy. Maybe it was a missile. I mean, all the stuff coming out of this is utter gibberish that people have been sold. And at some point, they got to start to apply some skeptical views as to what they're being told. But I think they're all in trouble. I mean, they set them up well, and now they're going to face a bunch of defamation suits they're going to have trouble with. So the reason why Dominion might be waiting, by the way, is if they plan on suing or believe they will get stuck in Texas, where Powell is a resident. Then the Texas has a lot of rules about 10-day notices for this in order to get this remedy, so on and so forth. So that may be what they're planning on. in what they're doing. But I think it looks like they set up a trap to launch lawfare against him. I mean, that Denver case was well thought through. They added a Denver defendant so they won't be dragged into federal court for diversity jurisdiction.
Yeah, they spent a ton of time on the jurisdiction to justify where they filed suit, which I thought was curious. I'd never seen it. I think it went on for like 3 or 4 pages. Why the court can exercise personal jurisdiction?
Because constitutionally, that's my Covington argument. So now in Covington, I have a harder time because I have a more uphill battle because I have to show personal jurisdiction under the Kentucky statute, which is stricter than the Constitution. But constitutionally, they're probably right because of I think I'm right in Covington. I have more evidence than I think they have in to show Denver, Colorado. But realistically, the reason why they won in Denver is they want a likely liberal Democratic judge, a liberal Democratic jury pool, a more liberal jurisdiction in the state in general. Trending that way. And so they know if they get that kind of jury pool, they'll issue whatever damages they want. And again, for everybody, I kept telling them, just as the big tech censorship campaign, they were using Alex Jones as the example. And a lot of conservatives didn't come to his defense. And I'm like, you just wait. They're using his example. And once they establish the precedent, then you're out of luck. And they did the same thing with him, in my view, and how they celebrated the Sandy Hook lawsuits. And I'm not counsel of record, so I can say what I want now without having somebody try to threaten me. I think that look at where they brought the suits. They brought it in liberal Democratic jurisdictions almost without fail. So they're repeating it. What happened with Jones was not going to stick only with Jones. They were going to repeat it. And I think a lot of it is politically motivated, but they created the problem in part for themselves by not being careful at what their sources were, and not applying strict evidentiary methods. Think about this is what I encourage everybody to do in a wide range of settings because I think it's useful for discovery of truth. Think of it like a trial. I'm on trial. What's my evidence? What is admissible evidence? What would a jury that doesn't have a bone in the fight think? What would a judge that doesn't have a bone in the fight think? They didn't do that, frankly, because they didn't apply the kind of discipline they should have before embracing theories that just lacked evidentiary merit and embracing other ones that personally attacked an individual, which did not have supporting evidence. Like you can see from our comment, that guy thinks there's a video out there. There's no evidence there's a video out there. That's the problem. And it didn't make any sense, folks. You can't have a super sophisticated secret spy operation by foreign governments and deep state operatives and him be on a Zoom call with Antifa telling him what he's confessing before the election. Think about it. Those two don't go together.
No, well, there's people reacting. I won't say viscerally, but they're reacting with an emotional response, which I can understand. It's what it is.
But that's how they suckered you. I mean, that's how they hoodwinked. The whole thing screams psyop. You look at, Q combined very useful techniques, the way that fantasy game builders build their fantasies out, with the way cult leaders organize their cults and persuasion techniques, the way new religions emerge, and the way you use high sales techniques. I mean, it's unlike almost any other anonymous messenger that's on a message board. So there's very unique techniques being applied, and it got people focused in a way that distracted them, that made them think they were participating when it was actually distracting them from positive, productive activity. And so and I think, and it was intended to radicalize them in many cases, to think that their only remedy was some form of violence or militia law or things like that. And so I think it was intentional. Now, I think Wood and Powell, are both victims of it. I don't think either one are deliberate participants. Like I said, I've had my view about Wood. I think he really believes a lot of these things. I just don't think he's operating sanely or operating the way a trial lawyer should. And then I think the reality, people have asked me, now I believe this was deliberate because the Q world was trying to infiltrate the Flynn camp for 4 years. And so I was actually, now I realize there are people that were connected to Flynn that referred me, these people that said they had inside intel and the rest. I met with them solely because Flynn world people referred them to me. I met them and realized they were totally full of it. And it was more like an entrapment effort. I disassociated from them entirely. But I think now that they probably deliberately targeted people like Powell and Wood. And if you don't apply discipline methods to how you vet people, you can get suckered into that world. And I think that's what happened. And maybe that's a good bridge into special counsel Powell and what that means.
Yeah, no, hold on. Not just there yet. I have 2 questions and then a super chat. One, people were making the argument way back when Dominion's not suing is evidence that, the allegations are true. Some people now might think Dominion waited too long to sue. So just in defamation law, and another question, can Dominion sue if they have over a certain amount of employees, because there's the issue that you can't defame a large enough group, but I imagine you can defame a company. So
Oh yes, you can definitely defame a company. So they'll be suing in their corporate name. Same with Smartmatic. Smartmatic probably has the easier case, just because the way that people like I mean, and to answer this one last time, I mean, Smartmatic owned a company that Dominion then owned, and because of it, they sued each other over it, and they worked together in the Philippine elections about a decade ago. That does not make one operating or owning the other, and the fact that and any lawyer would know that. So I get some, ordinary people don't necessarily are in the weeds of corporate structure, maybe got confused, but people like Powell and Wood knew better. And why they kept it's because they believe their sources. I mean, like some of their sources, always like this is why I recommend books by James Elroy and John Le Carre. If somebody from Cuba or Venezuela is an ex-spook and comes to you with some inside information, do not listen. Because that's the nature of just Google or DuckDuckGo, search Felix Rodriguez, and you can see who these people are. They're not to be trusted, period. Particularly spooks from those parts of the world. So, and apparently that's where a lot of this stuff got originally sourced. So I have no doubt that Wood and Powell thought they were being given super secrets, not realizing this was total nonsense. I mean, when you think that the bombing at the AT&T building in Nashville this past week is all part of a super secret plot, and maybe it was a missile, which is what some people apparently think, you've lost your mind. When you think a car accident was an assassination attempt, this is an attempt to distract and detour people's attention.
Well, Robert,
not productive.
I mean, I'm bringing up a super chat because she thinks, people. This is my issue. I know you get this response when you go after Q, and my view is when you go after the Q as an entity, you are going after an intention. Whereas some of the things they're entitled to believe, people are entitled to believe what they want to believe, and they can try to prove it. They can, when you go after it as an entity, it doesn't go after specific issues. And fine. I mean, and I see people don't like it, and that's fine.
If you're part of Q, you're part of a psyop, and you don't realize it. You may be the victim of it, but you're absolutely part of a psyop. It'll be something to study in time. And I'll have more reasons and explanations on this. I mean, as I saw how it developed, I mean, it was really quite impressive as a skill set. I think it started off as almost a game to see how much they could do. I think there's AI involved and other things too, because it has sophistication that doesn't. I think they use the pig farmers in the Philippines as a front. The one guy. I mean, just go look at who Code Monkey follows on Twitter and ask yourself whether you think that guy's a real cyber monkey expert, a real cyber sleuth, expert. But the other reason why I continued to criticize it, aside from the fact that I thought it was dangerous in its debilitating effect on people's independence of thought and of action, and leading towards a bad place, is I wanted people to witness how Q people respond. If I was wrong about Q being like a cult, then you would see them respond in the comment section with facts, with argument, with evidence. That's not how they respond. It's almost always confession through projection. They start shilling for a military intelligence. There may be some shilling for intelligence agencies involved, but it's coming from Q world. If you haven't figured that out yet, the Coomer defamation suit should be a roadmap for how do you get trapped into lawfare. They're going to be able to take out. They may be able to take out One American News Network altogether. Well, I mean, One American News Network couldn't survive a $100 million.
Well, they couldn't survive the judgment. But one thing I was saying also is, as far as a defamation lawsuit goes, it's not like they're going to get a judgment against OAN or Newsmax and not against other bigger players. So it's going to be one aggregate case, and they're not going to get a judgment against one. Basically, one defendant can piggyback off the defense of the others in terms of costs. But I mean, this is the thing. For people who think that Dominion couldn't sue because it's more than 50 people, I think it was the Kentucky Fried Chicken case.
Oh, yeah, you can't sue that many individuals, correct? Well, theoretically, it varies by case, it varies by jurisdiction. But a company can always sue for defamation. So the Kentucky Fried Chicken couldn't sue because the defamation was not of them particularly. It was of Kentucky Fried Chicken writ large, of all franchisees. So their standing was derivative as a franchisee. Dominion is just one company. So as one company, they can just sue as Dominion.
And just to answer that question, and like you said earlier, damages would be very easy to prove, and they're probably going to. Coomer as an individual, probably a private citizen, not a public figure. And
there's a reason why Fox went so. Even Lou Dobbs, who's a big fan of these theories, quickly started extracting himself from all of these issues, and Newsmax quickly started retracting. And I think I understand why One American News Network is doing what they're doing. They're making a massive gamble. Gateway pundit Jim Hoft, who I like, is making a massive gamble. And they don't understand the scope of it. And I think it's because they trust it was genius of the Q world to infiltrate the Flynn camp, because it got people who should have known better on board with some things they never should have been advancing and advocating for. So it was just that was not going to be credible. I mean, again, I just go back to the core evidence. If Dominion influenced the election, it should show up in the vote results. It doesn't. It's been refuted. Richard Barris and I both looked at it. So there's a reason why. I mean, and it's not like either one of us is afraid of going after someone or accusing someone of conspiracy. And again, and that's why I say there's a lot of projection. Just go look at the comment sections. Do you see the same kind of defenses you'd see when people are part of a cult? You do, consistently, and you see a lot of confession through projection. So a grift is when you go from 30,000 followers to 875,000 followers, like Lynn Wood did after he jumped on the Q train. So when you become Sidney Powell, and the other thing is, they're both raising money. They claim money's going to a 501c4 that doesn't appear to be registered yet as a 501c4. I'm not accusing them of anything wrong, but they're opening themselves up into a huge trap. Did they not pay attention to what happened with the Build the Wall?
Yep, I was going to say
doing this.
Cold fashioned pen. And the hold on, I just had one thought. It was about.
And by the way, Dominion's asking for all contacts and donor list. So you see how this looks like a deliberate setup. They got to out everybody who's potentially a critic, potentially a skeptic, potentially a donor, someone who could be targeted for suit, someone just like they did with Build the Wall. So that's why these things have to be done carefully. That's why when I established Free America Law Center, it's not a 501c4. It ain't any of that. It's just a basic LLC that supports important lawsuits that can't be done without some form of financial support, and to try to make it survive independent of me. But I was not going to give the IRS a list of donors. Or anything like that. I mean, there's a lot of mistakes being made. People can donate anonymously. They don't it's just all the signs of a trap, and they walked right into it. And I think it's not going to end well, unfortunately.
And I'm going to bring this up, Bryce, so that nobody thinks that we are not reflective of our own potential projection through confession through projections. Anytime I make some sort of critique of someone, especially Brian Stetler on Twitter, I reflexively make sure, is this a case of confession through projection? When you have the insight to ask the question, it's it doesn't negate the possibility, but it certainly tempers the possibility. So Robert is very self-aware and pays attention to it.
The reason why there isn't a lot of people criticizing and saying what they really think, people behind the closed doors have said very critical things of the whole QAnon world, is because it's not a good way to get followers to be critical of QAnon. I'll lose like 10,000 people the moment I criticize them, and I've criticized them repeatedly now for 4 weeks. Same with Lynn Wood. I get people attacking me. So getting followers cannot be the motivation for being critical of Q or Lynn Wood or Sidney Powell. Sorry, folks.
And now the last thing before I forget that I want to say is I can understand why people can be compelled or have the propensity to believe things which may be difficult to justify when you read certain things. Like when you read what actually happens in real life, you can see it. It's not implausible. When you talk about I don't know what the car accident thing you're talking about, but when you read how people were talking about intelligence, people were talking about, taking over Tesla auto drive cars as potential assassination attempts, well, then it becomes less implausible, or at least becomes more, it becomes plausible. It may be fantasy, it may be sort of far out there, but it's not far-fetched when in reality you have intelligence agencies considering the idea. So I tend to forgive it.
They mix truth with fiction, fact with fiction all the time. I mean, it's how a good psyop is run. So but there should have been what's the probability that some intern who was dating someone was just about to discover the real dark secrets of Dominion, who again, the evidence shows did not impact this election? That's the big problem. I mean, that's where you start. It was a deliberate assassination. So because they can do such assassinations doesn't mean that explains that. And doesn't that sound like a rabbit trail? I mean, look at how little focus ever got put on the signature match audit really occurring. When it was done in Arizona, 11% of the signatures, according to the Democrats' own expert, doesn't match. Almost no one has heard that story. And a year or two from now, almost all that will have disappeared from the mainstream narrative. The mainstream narrative will all be about Dominion and Powell and Wood. And what their goal is to get them hammered in courts where they're disfavored already, where they have bad facts against them, where it'll say, see, it was all a big lie all along. So it was all intended to be a disinformation campaign. And again, it's not because I think the election was done clean. You do a disinformation campaign to hide the culprit. You need a patsy so that the culprit isn't found. That's the point. You want both the how the crime was committed and who committed the crime to not be caught. So to me, the evidence of a disinformation campaign wasn't evidence of no crime. It was evidence of a definite crime. It just wasn't where they were asking you to look.
Now, this is the perfect segue because I don't know your position on this. I think I can anticipate where you're going to go, but for however you feel about Wood and everything else, what's going on with what state is it in now where the judge issued an order to show cause as to why he should continue acting in the Carter Page lawsuit? I forget what state it is. Is it DC?
Delaware.
Delaware, sorry. So for those of you who don't know, switching topics, switching gear, but it's a good segue. The judge in the Carter Page defamation lawsuit in Delaware just issued an order to show cause. I didn't exactly know what that was in Quebec, Canada. Order to show cause is typically for contempt. But apparently this judge issued an order. Okay, so he ordered to show cause why Linwood should not be have his pro hoc vice authorization withdrawn from this case. That is the permission to practice in a state where he's not certified for the Carter Page suit, because of what he's done in these other lawsuits in these other states, citing, affidavit issues, not disclosing or accidentally filing not under seal evidence that was supposed to be filed under seal, using all this as a basis to try to get him booted from the file where he's got court permission to exercise. I don't know your position on this. If I missed any important detail, let me know. But I'm predicting that regardless of how you feel about Linwood, I don't think you're going to be particularly supportive of this type of action by the judge, and it looks potentially political retribution or exploiting of the situation that has been created to leverage it to hammer Lynn, where otherwise no one else would get hammered for such conduct.
Yeah, so I think it's a couple of things with it. One is, this is the other evidence that this was a trap. They got one expert they keep citing who did the Michigan audit, who got caught, falsifying evidence by getting precincts confused between Michigan and Minnesota, by getting the digits wrong. So 51% turnout becomes 151% turnout. I mean, basic mistakes. You don't call yourself a technical expert, make those kind of mistakes. But that wasn't all. Then they got caught with a second super secret expert who turned out to be, an ex-mechanic who didn't have the cybersecurity background they claimed. A third one now has been exposed as being someone who's, has had fraud accusations against them and has had other accusations. It doesn't appear to have the cybersecurity background they claimed. So, I mean, again, it's the sign of a disinformation campaign to plant these kind of sources. And because they weren't properly vetted, they led them down this path. And then they made a bunch of procedural errors in some of these cases. And then there were spelling errors, technical errors, and courts were always going to use those as an excuse to come after you as a lawyer. That's why, especially if you represent outsiders or underdogs or a disfavored cause, then you have to always be, you have to be 110% perfect. That's just the way of the world. And that's why this was careless and reckless. But it's because they haven't really done this systematically. It's one thing to defend Flynn in criminal court, in some criminal cases. It's another thing to really be in the weeds of these kind of wars every day, or to be doing some defamation cases where you're on the popular side of the equation. So neither Wood nor Powell has really been through a lot of true trial lawyer wars of being an underdog in the case. And so they got set up, and they got set up effectively. So now I think without question, to give a shout out to Rakita Media, what is his YouTube?
Nick Recchietta is his channel. Does great stuff.
That's it. Yeah. He has some interesting followers.
I should spell it. Recchietta is Rekieta.
Yep. He's another testament to smarter lawyers being those people who come at the law from working a real job rather than how many, he did a good interview with Eric Hunley of the Unstructured podcast, who we also recommend always, because he does fascinating interviews with intriguing people. But he made a good point about how if you come at law from, and some people have been asking this question on the locals board, I always encourage a law degree because it can't really hurt you. It can cost a little bit of money, but these days there's online programs that are really affordable. It always gives you more economic options in life, and the more ordinary people that have law degrees, the better. because we have a bunch of schmucks with law degrees today. Just look at our federal judges. But the and you know, the whatever judge I'm in front of next is an exception, of course. Getting to the pro hoc vice, it's the judge probably is making a mistake here. Clearly politically motivated. Rikita did a good analysis that's clearly politically motivated, whatever mistakes Wood may have made. In that one, the judge is clearly like trolling or following other cases that have nothing to do with his case, nothing to do with the state of Delaware. So why is he paying attention to that? Really, that should be a warning to Carter Page. He needs to get rid of that judge by some means, because he's got a problematic judge who's that political that he's tracking whatever case Wood's doing.
I just want everyone to actually focus and just pay attention to that observation that you just made, which is not one that anyone has made that I've heard of yet, but it's the most astute observation. Is this is how you detect you're in a bad situation where, as much as people don't like settling fight on principle, it's as good an indication that you have a judge who's going to go out fishing for stuff to hold against you, as opposed to wait for it to be presented to him. But sorry, go on. Great point.
So the second mistake the court's probably made, judges make this mistake a lot. They think that motion to pro hoc vice is always within their discretion. So it's the Latin for to appear this one time. And if you are a lawyer not licensed in that jurisdiction, you have to ask for permission to appear. Now, I personally think we should have, I'm not even in favor of bars, Supreme Court's controlling your law licensure. I'm not in favor of licensure, period. I think anybody should be a practicing lawyer, and you just have to have truth in advertising as to what your experience is. I agree with Andrew Jackson's. I strongly disagree with Dershowitz on. If we have him on down the road, that's a debate topic.
It's in the works.
That's way too much. God bless him. Brilliant lawyer. Still trust the professional class too much. But in order to appear in Delaware, you have to ask permission of the court. And when you first ask permission, the court has broad discretion to deny it. So on almost any grounds, even in criminal cases sometimes, which there should be a Sixth Amendment right to counsel, but they've interpreted that as not to meaningfully apply to pro hoc vice applications. So sometimes they moderate that, but not often. So, but here's the problem. Once a court grants a motion to appear pro hoc vice, you as a lawyer now have a due process right in staying in the court process, and the court can only remove you for misconduct that can happen while you're in front of that court. Now, I'm aware of this because I have opposing counsel come after me all the time. I appear motion to appear pro hoc vice all over the country. I think I've appeared in almost every state court, every federal court in the country by this point, or pretty close to it. But I will run into lawyers who don't want me to be on the opposite side, and they'll fight tooth and nail to keep me out. And then once I'm admitted, there's some, like the Sandy Hook case by representing Alex Jones, they kept begging to kick me out every 5 seconds. And it was based on my speech. They wanted to use the fact that I had been admitted into court as grounds to control what I could say about the case publicly. Now, their attempts to deny me and strip me were denied because they have to prove that I violated a professional rule of professional conduct in that state when I did it, because I have a due process right. I would almost guarantee the Delaware judge doesn't know this, because I've run into judges who are like, "Oh, I thought I had total discretion." Nope, not once you sign that slip. Not that game changed. So he probably doesn't know that, the Delaware judge. Now here's the sequence of issues that's going to be a problem for Wood and Powell. Is these litigants are now the Michigan Attorney General seeking sanctions against them. Other places are going to start seeking sanctions. They're going to use the defamation suits. They're going to use this is why I say it was a trap. They were using it to build up to where they could disqualify 2 lawyers they saw as a thorn in their side. Now, I personally have not been a big fan of Lin Wood, but clearly people that saw him as a political adversary of some skill. And clearly the case, they saw that with Sidney Powell because of her success representing General Flint. So they've now put themselves in a position. You go through the history. Every dissident lawyer has been challenged at one time or another, almost all of them without fail. Clarence Darrow, I think he faced 2 criminal trials, maybe 3. I mean, if you're good at what you do and you fight the system will target you and the system will harass you. What annoys me is that they walked into this so easily in what they did here. So I think Wood should win the order to show cause. I hope he picks some other counsel. That's not necessarily his area of expertise. Let's put it that way. and he should have someone else advocate for him. Someone that knows constitutional law, someone that someone like a Dershowitz type that can come in that's from the opposite political side that can say, hey, no, someone the Delaware judge will respect, probably a Democrat. These Delaware people are going to be feeling high. It's not remember that it's Delaware, and where's Joe Biden from? Where did he build his political machine from? So maybe that's why this Delaware judge is paying special attention. If I would look into everything, see whether there's a political angle here that could be pursued.
Well,
But I'd be most concerned that I have a bad judge for Carter Page. That'd be my biggest concern, not getting included from the case.
Interesting thing. What you said was that, first of all, that Wood should take it as a compliment to some extent, because typically you don't want to boot out an incompetent attorney. You want to keep him in. So Wood will take it as a compliment, and it might very well be one, but they should be paying attention to how this judge is going to rule on the merits against Carter, because this is a broader indication of a problem. I guess the question then would be, what are the chances of a recusal if they allege the things that you're alleging, that this judge is taking judicial notice of issues that have nothing to do with this case? Is that a clear enough bias?
I would be aggressive. I would be smart. Don't be careless. But I would be aggressive if it was me. I've had to be when I've been in this position. They've never had good grounds to ever even try it, and I just educate the judge on the law, and the judge judges always recognize that and back down. But and you have to present the argument in such a way that the judge feels that the law better than anyone else in the room does, and that's important to communicate that. And that's what I'm saying. You need someone like that. Because he is, like I said, I've never known Wood to win a jury trial on defamation in his life, to my knowledge. So I think Wood's a good PR lawyer, not always the best courtroom lawyer. And like I've been open about the fact that I think he's lost his mind over the last year. That was before the Q stuff. That was when your own partner sue you for saying you're a crazy fraud. That's probably a sign. But I think it's a bigger warning sign for Page. Maybe he can use this as a way to get a new judge, but otherwise he's facing an uphill battle. And in a lot of Page's cases, he also has John Pierce as a lawyer. So he's got a very good lawyer that brought the DC case. That's the lead lawyer. But John Pierce on your file is not a good idea. And honestly, Lynn Wood is probably not a good idea at this point because of what's coming down the pipeline. And the same is true of, unfortunately, with Sidney Powell, which may be a bridge to the special counsel conversation.
Yep, let's do it. And I'll just end with my thought on this is that, I would always be of the opinion to forgive the judge for the lawyer for what might otherwise be unforgivable mistakes. Reading through the proceedings, there were unforgivable mistakes in those proceedings, but you're drafting in, 24/7 in different states, and you have people doing work for you.
Clearly, Wood was just a co-signer. I mean, Wood is not leading any of that litigation. I don't think he's appeared in any of it. He's doing his own case where he did the plenty of perjury mistakes, which he admitted this week. But and again, it's the problem with people that are sort of in over their skis. But no, I agree that to date the things even he cited were mostly procedural errors on a rush timetable. Very few of them. I mean, the bigger problem is they have witnesses that are not being honest or forthcoming. Affidavit. Yeah, I can tell you the story that's coming. The story that's coming is they're going to accuse Powell or Wood or both of writing the affidavits for the witness, and that the witness when you have unreliable witnesses, watch some of these witnesses turn around and point the finger back at Wood or Powell. So I mean, one witness kind of already did that. So that's why you have to be. You're about to jump in. If you really believe there's a bunch of foreign governments and spooks who stole the election, that's even more reason to be extremely careful with what information you're vetting and what you're going to present, because that means you're up against. If you really believe that, you have to behave very differently than they have unfortunately behaved. And I think but unless you believe the Q thought that really there's a bunch of allies, they're just waiting to have an excuse to unleash the military and everything is. If you really dig into the Q fantasy world and you're one of the players in the Q fantasy world, you think you're playing into the script, the final script, not realizing that final script isn't the script at all. It's a setup from day one.
Okay, and that's a good segue. Now, actually, I'll just bring this one up. Dapper Dave says the judge delayed the Kevin Kleinsmith case. Any chance Biden pardons or grants clemency? Any other people that might be charged by Durham? Well, first things first. I mean, if he's going to get sentenced to 6 months, if Biden takes office in January, he can grant clemency or pardon then. So I don't think the delay is going to add much, but it's an obvious possibility.
Oh yeah, and if Durham does anything, I'll believe it when I see it. That's what I've been saying about Durham a long time. Durham covered up CIA, illegal torture and illegal spying, so I have no confidence in him doing anything. He couldn't even get a report out before election day. So come on, at this point, the people who still believe in him or Barr, I can't see that. Both of these guys turned out. I mean, Barr was definitely a traitor to Trump. Zero doubt about that at this point. I mean, Barr probably did more to help Biden win than person in the entire country, more than Dominion, that's for sure. By sitting on the Spygate scandal, then keeping hidden the Biden criminal investigation, even while Trump was being impeached, knowing he was being impeached on a false grounds and keeping his mouth shut about it, and then lying about saying there was no fraud in the election that he had failed to meaningfully investigate.
Someone told me they respect Barr's integrity, in that he kept quiet on the Hunter Biden. I was like, he kept quiet on that while he made public statements about a non-investigation of issues. I said, you call that integrity. I'm not calling it anything else. It's just these are also mutually incompatible actions as far as integrity goes. Okay, Sidney Powell, a story that I thought had to be fake when I saw Maggie Haberman tweet about it. I still think it's a misrepresentation of what happened, and there will never be a retraction. But if my tweet ever ages well, I will bring it up. What's the deal? So that she was being apparently floated as special counsel for election irregularity inquiry. What's the deal on that?
So Powell has wanted control over the litigation all the way through, and I have voiced for most of the time it was behind the scenes. I had said she doesn't know what she's doing and she's wrong on the facts, and she's leading the case astray in a problematic way that will undermine the president's cause now and in the future. And that has been mostly borne out. I mean, the Kraken cases have gone nowhere except expose both of them to now defamation claims and liability for as lawyers. So the idea that she should be further involved, I understand what Trump might have been thinking. And I think this was the pitch. Is that Trump's thinking, well, she'll go after everybody, so why not appoint her? Regardless of where it leads. The problem is, as people inside the White House have made clear to him, they don't know what they're doing. They're completely wrong. They're leading things astray. They're misdirecting activities. And not only will they kill any remedy that could possibly come about now, but more importantly, kill any legacy. And so I think that the effect of it, now what she was actually, apparently whether she was proposing it or Trump considered it, none of that is clear, was just to be White House special counsel, which doesn't really mean much. So a White House special counsel has no prosecutorial power. They can't form grand juries. They can't subpoena evidence. They're just an advisor that sits in the White House. That's about it. They might have some access to security information, but do you think that she's going to get those security clearances? Given if her allegations were true, then she would never get the clearances. If the allegations are false, then it's reasons to deny the clearances. So I didn't see any utility aside from her continuing to be a sideshow that has needlessly harmed and undermined Trump's case. And I think she's bought into a lot of stories that aren't true, evidence that isn't true. I mean, we have 3 witnesses now that turn out not to be anything like they were promoted as, or got basic facts wrong, that are now she's being set up to be accused of suborning perjury. I mean, I don't think she realizes this, but that's what's happening. I mean, it's one setup after the next that's meant to be career reckoning and legacy destroying, and they want it to splash onto Trump. So in order for her to be a U.S. attorney special counsel, the attorney general has to appoint her. And then she has the power of grand juries. And I think the idea of a special counsel to clarify what took place. Hey, if we could do Mueller for what was complete nonsense, then, Trump is entitled to have his own special counsel to look into how Biden got elected and everything related to Hunter Biden. Turnabout is fair play. Now, reality is I don't think the attorney general has it, but Powell wouldn't be the person to do. Find somebody smart and aggressive on the right who can deliver. That's who knows the criminal process and knows politicized management. And again, Powell mostly has been a criminal appeals lawyer. So she is not much of a criminal trial lawyer. And isn't by her behavior over the last month is not well equipped to handle this roadmap at all. So it would need to be someone else. I think the idea of a special counsel is a good one. I think hopefully the U.S. attorney the attorney general will sign off. I don't believe he will, because the guy that replaced him that Barr had recommended in the first place is an old Bushite and a very deeply establishment guy. So I don't see him doing anything. But if we had an honest system, it would happen. Now, maybe not be the best precedent to set that we always appoint a special counsel after every election to investigate the new winner. I'm not a fan of that as a process.
That is
But
the
in
world.
this context, that it's fair. Turnabout is fair play, and honestly, it almost has to happen to discourage it from happening in the future. Otherwise, it'll just be selectively used against the political outsiders and the politically disfavored. So I think there'd be utility. I mean, in order to build the country's confidence in what happened, you would want someone with impeccable integrity and impartiality, or who's willing to go forward and find wherever the evidence leads them, go accordingly. And you could probably vet certain allegations to show they weren't true, and vet other ones to see what were true. I think with Biden, that the Hunter Biden clearly would need one. Now, here's the other problem: anybody appointed for Hunter Biden, Biden can fire, or his new attorney general will. So I don't, having a special. People have been suggesting that having Durham as a special counsel somehow make him immune from firing, and a new special counsel that won't happen. But Biden doesn't need to tell his attorney general to do it, just like Obama didn't. Which actually may be a good transition into the Blackwater and the pardons.
Yeah, and I think
Democratic attorney generals know how to behave.
This might be the last subject of the night. We might not get into the lockdown Pineapple Saloon lawsuit, but maybe we'll have news and have a better talk of it later. Okay, so Blackwater and the pardons. So despite I put out a video day before yesterday. I don't know. It was this week talking about the pardons. Power of the pardon, absolute, despite what certain judges question and what other lawyers think. You can't get impeached for a pardon, and nobody can tell you that your pardon is invalid. So there will be no issue on that. How they get exercised.
You can't reverse a pardon like some idiots are proposing. The same people that tell you standing is a serious legal doctrine on the left are telling you can reverse pardons. I mean, that's how political they are. I mean, they've quit being impartial, objective observers of the law of any kind, unfortunately.
No, so I mean, and I'm seeing it, and I didn't, I have to double check things myself. I don't only listen. I listen to you. I don't only listen to you. I listen to the people who have proven themselves to be unreliable, just so I can know what other people are hearing, and I need to verify it myself. So I feel satisfactorily confident in believing pardon's absolute. Can't get impeached for it. It can't be reversed. Maybe they can try to dig up other issues to go after the person as retribution, whatever. Or reprisals, I should say. So Trump has pardoned a bunch of people. Charles Kushner, Jared Kushner's father, I think that pardon looks bad. It smells bad. It might be bad. It probably is bad. And it will allow other pardons, which might be more questionable, to have a sort of a doubt cast on them. First things first, a lot of people think pardons should, they go to the most deserving of these egregious injustices. How do pardons typically work? I'm seeing that they look to be politically oriented 95% of the time.
No doubt about that. And I think, the way Trump has approached it is actually, I would say, much more disciplined and less political than his predecessors. So, W pardoned a bunch of political allies. Clinton pardoned a bunch of political allies. Poppy Bush pardoned everybody connected to Iran-Contra. So and those were real scandals, frankly, compared to some of the made up or built up scandals in the cases of the people Trump has pardoned. But they pardoned, frankly, more, and they exercise the pardon power a lot more than Trump has. So that's part one. Part two is mostly, if you look at Trump's pardons, they fit two themes. They're either people who have long since served their sentence, who he believes have done steps to make their lives better and to make society better. And so they deserve to have this stain on their reputation removed. And that's why he did Kushner's father-in-law. His son-in-law's father.
Charles Kushner.
Yes. So there was some things that guy did or was accused of doing that where, I used to say he wasn't necessarily the brightest criminal in the world. But at the same time, there were some questions about tactics Christie chose to use in that case. So there are some fair questions because that kind of ties into the other theme. So, and in those themes, when people get all mad about Kushner, it's like he's already served his time. You just care about what label is put next to his name.
Well, they care about whether or not he has his civil civil disabilities removed. He can run for office. He gets perks that low level marijuana offenders don't get just because they're not the father-in-law of Trump's son-in-law. And I see it, I feel it, and I see that's the way it looks. It's going to be very difficult to convince anyone otherwise.
I'm not in, I agree with the left. I'm not in favor of a lot of those lifetime punishments for people on civil remedies. So I think all your rights should be restored. Now, usually, like most felons can get their rights restored, so he may have already got his rights restored, and he may live in a state where that's easy to accomplish anyway. But my view is that once you serve your time, you serve your time, and there shouldn't be a lifetime punishment of voting. It also creates bad incentives for the state to do bad things, to go after people, to simply deprive them of the ability to run for office. I knew a great judge in Chattanooga that served time and got his sentence expunged and all the rest because of good acts. And he made a great judge. It was ridiculous that he was ever put in that position, in my view. So I don't see those as that problematic. I see that as mostly just, saying, hey, they've done good stuff, and I'm going to reward them for doing good stuff by restoring their reputation. And to the degree they're restoring their civil remedies that shouldn't have been removed from them in the first place, in my view. The theme for all of the others that he pardoned is that you have been identified, to him at least, as victims of politicized prosecutions. And in my view, so I thought, okay, I can't look at all the cases. Most of the people he pardoned were people that already served their time or large parts of it. I mean, even Manafort had served a large part of his sentence. So I looked at and was older already, and putting him in further prison didn't even make sense in my view. Whatever you thought of Manafort, though clearly he was targeted for politicized purposes, and there was all kinds of problems in that prosecution beyond that. But I figured I'd take the most controversial one, the Blackwater one, the Blackwater 4. And digging in, I was shocked at how much the media's campaign against these guys are built on lies. So basically what happened is they were purely politicized targets. So, they were defending diplomats and protecting diplomats in Iraq. Well, again, we probably shouldn't have been in Iraq in the first place, but that's not their fault. They were Blackwater contractors. They went to secure a local square near where this diplomat was in trouble because they thought that was necessary and had been a prior source of problems. And they go and they do that. And when they go there to do that, they believe they came under fire. Several of them fire back. Then they leave. The State Department investigates and clears them. 3 weeks later, the FBI takes up the case. What happened was they end up getting caught in the middle of a transition. W leaves and Obama gets elected. Obama wants out of Iraq because he promised to get out of Iraq. He wants political cover to do so. And Obama's anti-Blackwater. Blackwater, Eric Prince, and other people are tight with Republicans, not with Democrats. And he doesn't so he wants to sort of have a smear on Blackwater as well. And Holder takes up the case, and they do every kind of shenanigan name you can imagine. I mean, they manipulate venue. Like the case is tried in D.C. when none of them live in D.C., because they tell one of them, oh, can you fly into D.C.? We need to talk to you. And then they have him appear in front of a federal judge and then claim he was arrested, even though they never physically arrest him. And they use that as the jurisdictional pretext to have the entire case decided in D.C. The initial D.C. judge dismissed the entire case because it was the product of either improperly immunized information or coerced testimony in violation of the Fifth Amendment. Somehow the D.C. Circuit, of course, finds a way to reinstate it and says, well, you can pretend all that tainted fruit doesn't exist and still bring a prosecution. That's how we enforce the Fifth Amendment in America. And some of that, by the way, is thanks to Scalia and some justices who've made some bad rulings on that. Who've wanted to get rid of certain rules from Miranda and the rest from day one they got on the bench. That's why they're selectively originalist. A lot of these supposed originalists. Thomas is the only one that even cares, in my view. So then the case gets reinstated. One of them gets dismissed, and they bring him back under first-degree murder charges, even though they have no real evidence of that. Much of the evidence it doesn't exist because there was some of the evidence that does exist doesn't show up until 7 weeks it doesn't show up for 7 years until midweek of the trial, midway through trial, which include photos which appear to refute a lot of their claims. They were going around offering to buy people's cars that supposedly had ballistic proof of damages. Well, of course, that's Iraq, where you're basically bribing witnesses, saying, hey, you want some money? Say you were here and that something bad happened to you and that these guys did bad, and we'll pay you for it. That's basically what the government did. They apparently suborned perjury that came out during the sentencing stage where somebody's victim impact statement directly contradicted their trial testimony. They got one person to confess and cut a plea deal. He's the one who admits he fired just everywhere. But then they get him to shift the blame during trial, and his story changes 4 or 5 times. There was evidence at trial that they came under fire and fired back, and there was the number of dead and wounded kept changing. One, it's 9, then it's 18, then it's 34, then it's 42, then it's back to 14. I mean, how does this happen? What happened was politically, internally in Iraq, they wanted to make an example out of it. In order as an excuse to limit U.S. military presence. Obama wanted a political excuse as cover to get out and to go after Blackwater. So these 4 guys were set up as to be examples. And there were issues with venue, issues with evidence, issues with perjury, issues with how the judge ruled, issues with the whole trial. The sentencing was totally out of whack. Sentenced them using a gun statute. The main sentencing basis was the use of a gun statute that was intended to go at drug dealers who use machine guns. And because they were convicted of voluntary manslaughter, they added on the gun charge to get him like 30 years. And I mean, it was just, so there was a lot. Once I dug into the case, it's not at all like what the media is presented. In fact, the media story doesn't really make sense when you actually dig into the evidence and what evidence exists, which is limited because they had no ballistic evidence, almost no forensic evidence, almost no live witness testimony that could be confirmed in any manner, lots of unreliable testimony of people's memories that kept changing, testimony influenced by money, testimony influenced by Iraqi prime minister, testimony influenced by the State Department and the FBI to selectively remember this and not that. That I have serious doubts about whether they ever did what they've been accused of doing. So I think the president exercises independent judgment right in that case.
And so, I mean, I looked into it summarily over the weekend. Some of the interesting facts were that the chief eyewitness apparently had ties to insurgents himself.
Yes.
But I mean, the bottom line is, you're looking at a situation where final tally, years later, 17 civilians were shot and killed. And
apparently, I mean, they still don't know because they got different autopsy. Like initially, the reason why the number came down is they submitted a bunch of autopsies saying these people were killed, and they realized the date of the autopsy, but there was no autopsy of the people that they have said died from these guys. Doesn't exist. Instead, they came up with death certificates, but many of the death certificates initially did not even were people who had died before that happened. So that gives you there's just no reliable evidence other than 2 people who definitely died at the scene. There's no evidence of who else was shot by whom, from where, what happened, how many died, how many were injured. Nobody knows.
All right. And people are going to say, we're satisfied with what we've seen in the news. 17 civilians, armed security guards, just, opening fire, and Trump just pardoned mass murderers effectively.
It fits the narrative they like about Trump. It fits the narrative they like about Blackwater. But it doesn't fit the evidence that I saw or read.
And I think at the end of the day, everyone should, do your best to look into it. It is one of those gross situations where one way or the other, it's a bad situation. And, like I said,
it shouldn't have been there. And
it shouldn't be in a foreign country. They're in a foreign country, running around, with armored trucks and machine guns, helicopters.
It's especially dealing with insurgents. I mean, you're dealing with insurgents who are going to fake things, who are going to stage things, who are going to set up things to make you look bad. I mean, it's just the nature of it. It's particularly insurgents who don't believe in any limits on the nature of warfare. And frankly, that was the nature of a lot of the Iraqi insurgencies. And you're in a country where tons of people are willing to come forward because they don't want you there. So that's the problem. Credible testimony, all of it was difficult. And then, but my view was the fact that they bought testimony, the fact they didn't present ballistics, the fact that they hid exculpatory evidence, the fact they manipulated the venue. You don't have to do that if you have a clean case.
All right. And now I should mention my chat has been frozen again in StreamYard. So I've missed all the super chats for at least, even my comment saying that my chat is frozen did not come up. I'm just checking on YouTube. So for everybody, I'm sorry. I can't even bring up the chat anymore because I don't see it. But I think, look, this is an interesting one. This is the one where you can understand both sides. This is one also where now that you've seen what happens in the fog of war and in the fog of the media war, and when you've lived what you've lived now, you can see how there might be more to the story than was reported by the New York Times at the time. And you can see also that, you may never be satisfied one way or the other, and that you might think should never have been there. You should never have people running around with, heavily armed security detail in a foreign country that you have no business being in. This is what happens when that happens. It's like a heavily armed police force. They're going to use those weapons at some point for, whether or not there was a shot fired to trigger it. And it's an ugly situation. But yeah. I looked into it, because the one-line tweets, there's more to the one-line tweets. And however I feel about this particular part, and it's a complex situation, and it's going to lead to the other.
Yeah, it has the fingerprints of a politicized prosecution. Yep. So again, if you have confidence in your evidence, you don't have to hide evidence. You don't have to suborn perjury. You don't have to manipulate venue. You don't have to manipulate charges. You don't have to be buying off evidence. You don't have to do those things if you have a clean case. They clearly did not have a clean case. And and there were some locals questions. Some of them I'll respond to about whether your employer or educational institute can require COVID vaccines as a condition of education is actually an ongoing suit that the Children's Defense Fund has helped bring in California. I'll share some of the contents of that suit on our locals board and I'm still researching that question. Same with masks and COVID testing, when HIPAA applies, when it doesn't. It may be the case that we need a new informed consent law, the Nuremberg Accords, to be implemented. It was sort of presumed that they were a part of our law, but it's clear some courts may not consider it that way, or at least some employers currently don't. Some educational institutions currently don't. So that will be the next wave of ongoing litigation. And then somebody asked about about the building a movement, which I'll be doing on the locals board some more different ways people can meaningfully improve their life and the life of those around them. It always starts here. Self-education is self-improvement and self-empowerment. And that's the best place to start. And then know your rights, know your remedies. But there's other things that people can do. Pay attention to the fact that elections are local. That's where it's going to start. That even when it's a federal presidential election, the votes are being counted at your local county. And there's a lot of places to make major change and reform that we'll be coming up with. Be working with Richard Barris on, coming up with proposals on that. And then someone asked about, what if you believe the government is beyond redemption? My view is that then it's changing the government and finding the means to do so. And usually that's going to almost always be within our constitutional democracy. It's the best experiment so far of any government out there. What's the practical alternative? So I think there was an aspect of Q that was a psyop that was meant to recreate the militia camps of the 1990s. That's not a solution. Just look at how that ended. The end is public persuasion, democratic reform, self-improvement, self-education, and making differences with those around you. Those are the only methods that have worked over time, whether you're talking about our revolution or you're talking about Dr. King or Gandhi or others. Other forms of revolution. Our revolution worked because of the way Thomas Paine's message spread throughout taverns throughout colonial America, not because of military tactics. George Washington never really actually won a single battle. The battle we won was in the court of public opinion. That's what changed things. So the power is still with ordinary, everyday people. And so I never believe our government may be beyond redemption, but that doesn't mean the means of reforming it should be anything other than constitutional democratic means.
I love it. And I love that that's the way you phrase it, because I think everybody here needs to appreciate that, despite some of the more inflammatory rhetoric in the comment section. And people are asking about the forced vaccines, HIPAA violations and face mask laws. That I think will actually be probably the best discussion to have with Dershowitz, because I know you're going to disagree on some big stuff and it'll make for a good talk and an enlightened debate. So that's going to be my pitch to Alan this week, to get him, if it's not next Sunday, maybe the Sunday after, but maybe next Sunday, because it'll be the new year and it'll be a good time for discussion.
Yes, we can explain the problem. I think it's called Dunger, whatever it is. It's the mental process whereby an expert who would be very skeptical of experts in their own field is unduly deferential to experts in other fields. And in my experience, Dershowitz is a sufferer. So we're going to help him.
Amazing. All right, everybody, with that, sorry I couldn't get to any of the chats for the last 20 minutes, but this was another phenomenal one. We're not going to have a live stream until in the new year. So everybody, Happy New Year. Health and happiness, and above all else, liberty in 2021. May 2021 be freer than 2020 has turned out to be. Robert, I'll talk to you before, but we'll say our proper goodbyes afterwards. Everybody, Happy New Year. Robert, final word.
I'll be over for the next half hour or so over at our locals board, responding to subscribers' comments or questions. And if you're really agitated and want to troll, that's where you can troll me. So vivabarneslaw.locals.com.
Everybody, have a good rest.